My name is Sal Luciano, and I'm the president of the Connecticut AFL-CIO that represents about 250,000 unionized workers. We're here today because the governor thankfully vetoed a bill that would have taken away workers' rights to address wage theft both in the future and retroactively. This bill would have unconstitutionally taken away workers' current property rights and taken them away retroactively. It's important to note that this stealth inclusion came into being after tip workers were deliberately delinked from the minimum wage, a conscious decision not to raise tip work from $6.38 an hour. These working people became the only class of minimum wage workers not to see a 90-cent increase on October 1st, the vast majority of whom are women and minorities. The governor's veto shone a bright light on the lack of any semblance of transparency, even by the General Assembly's end of session standards. Legislators did not know what they were voting on. They were told that the bill made technical revisions. How big is the problem of wage theft of restaurant employees? The National Department of Labor investigated 9,000 restaurants and found that 83% had shortchanged their workers. 83%. As a result of the veto, there is a working draft, LCO 11202. In all my years of testifying, I've never testified on a working draft. This draft closes only one class of workers to not be able to file class action lawsuits to recover wage theft. In addition, it takes away their ability to go to court at all, since in many cases it would not pay attorney's fees. Who can pay an attorney a few $1,000s to recoup $100 that was stolen from them? Today is crucial because after the veto, many voices were heard from the Restaurant Association, but none from the people who make the restaurant experience so wonderful. And we're here today to hear from those who have been excluded from the conversation. First up, we have James Bandry Alexander, staff attorney at New Haven Legal Assistance Association. James.
Thank you, Sal. Sal mentioned a lot of the concerning aspects of this proposed compromise, and I want to start by saying that for low-wage workers that I represent at New Haven Legal Assistance, this is part of death by 1,000 cuts. As Sal said, the tip credit, which is a sub-minimum wage, exists only for this workforce. And who is this workforce? 66% women, almost all of them in the bottom half of the income distribution, an average wage, according to the Connecticut Department of Labor, of $13. So from that basic foundation, a rule was made in 1950, a rule that is 70 years old, a rule that predates almost every restaurant in Connecticut, which said to restaurants, you can pay a sub-minimum wage, but only for tipped work. If you have somebody cleaning the bathroom, if you have somebody mopping, if you have somebody setting up or closing down a restaurant, you have to pay the full minimum wage, which is now $11. HB 5001, which was vetoed by the governor, would have removed that protection from workers going forward and retroactively. It was a good idea to veto. Now we have compromise language. But what is the compromise, and who is it between? Is it between workers and restaurants? No. Is it between workers and the legislature? No. It's between politicians, no offense, we love you and thank you for being here, and the Restaurant Association. We need a process that includes the concerns of workers. A bill that doesn't include something positive for workers is not a compromise. And I want to point out one more thing legally about the compromise working draft we've seen. Actually, 2 or 3 more things. One is it opens up all the tip credit regulations in the context of the U.S. Department of Labor, Donald Trump's U.S. Department of Labor, trying to make these standards as weak as possible. So the new federal standard is going to be which we will hopefully not conform with in Connecticut, but we're on the way, that tipped workers can do non-tipped work for as long as a restaurant owner thinks is reasonable. That's no standard at all. So the move here in this compromise draft is not just about one little regulation. It's about opening all the regulations and eventually conforming them to the very weak, non-protective federal rules. The class action language that's in the working draft, it looks simple enough, but when you start thinking about it, it's very dangerous. It says that in order to be a member of a class, if you are one of these female, low-income, low-wage workers affected by this bill, in order to bring your claim as a class, you have to prove individual damages before you can join the class. Now, what's the problem with that? These are all cases, by definition, where the employer did not keep the records necessary to prove individual damages. So what does the class action language do here? It really functionally removes the ability of low-wage female servers to bring class actions in the state of Connecticut. You're going to hear in a lot of testimony, and I think a lot of it earnest from restaurant owners, about how difficult it is to comply with the rules. Well, I was a server who was a tipped worker who did non-service duties, and this was some time ago. But when I had to change from one role to the other, I just clicked a button. I just pressed a button, and I went from one pay rate to another. It wasn't very complicated, and the rule is 70 years old. So all in all, I just want to say this bill is a little bit more far-reaching than it's being represented as, and it really masks an agenda to weaken 80 years of wage protections here in the state of Connecticut.
Thank you, James. The next speaker is Kim Davis, a tip worker for over 30 years and member of Unite Here, Local 217.
Hi, good morning, everyone. My name is Kimberly Davis, and I work at the Hilton Hartford Hotel as a banquet server, and I also work in the Urban Kitchen restaurant. I've worked at the Hilton and other restaurants in the area as a tipped worker for over 30 years. My experience as a tipped worker has been very different depending on where I've worked. At the Hilton, where I'm a proud member of Unite Here, Local 217, I have been extremely fortunate to have the protection of a union and a collective bargaining agreement. This is the only employer where I have not had to face things like wage theft. Other restaurants that I've worked in the past that unfortunately did not have union representation, they've skimmed our tips to pay for the credit card company charge fee. Or sometimes they'd hold all of your tips that you earned for several days before finally paying you. And you didn't always know when that would be. In the low-wage, paycheck-to-paycheck life many tipped workers live, this can be a real struggle. Many of my colleagues at the Hilton have had similar experiences at other restaurants. One of them is Ryan. He used to work as a server for Morton's Steakhouse in Hartford. While he worked there, management would illegally take a percentage of their tips to give to subsidize their own salaries. Ryan, as virtually all tip workers, were paid the sub-minimum wage and relied on tips to make ends meet. But the owner and management conspired to steal a portion of those tips. And this is not an isolated incident. Wage theft is prevalent in the restaurant industry. I think it's important for tipped union members like me to speak out for non-tipped workers, non-union tipped workers. I know from working in other establishments what it's like to be cheated out of not just your hourly wages, but gratuities you earn through your own hard work. I know what it's like to understand that if you challenge the boss, you could be fired. And I also know what it's like to work from the minute you take your coat off to the minute the restaurant closes, not getting any kind of a break. I know what it's like to regularly work without having to take a break, essentially providing the employer a free hour of your work time. This has to stop. Instead of making it easier for restaurants to get away with wage theft, we should be making it harder. We all need to stand up and fight to protect Connecticut's lowest paid workers. Thank you.
Thank you. The next speaker is Valerie Nettleton, a former server at Denny's in Westbrook.
Sorry about that. I'm going to speak from my experience. If the laws go through as they are, what will happen is people will be taken advantage of. I can tell you right now, that's what will happen. People will be taken advantage of because the 80-20 rule, it doesn't go like that when you work in the restaurant industry. You are required to do much more than serving your tables. You're required to do cleaning. You're required to do takeout orders. You're required to cut fruits and vegetables. And I guess that's all I want to say. Well, actually, if this law goes through, it would hurt someone like me because I wouldn't be able to hire an attorney to represent me if they're not being paid through my lawsuit. Then there's no way I could afford to pay an attorney. I'm a mom of 2 kids, and I work part-time as a server. I love serving, but the legislation has to change. It's just not good for if you're working in a tipped industry. You're being taken advantage of. That's how they do it. If there's no separation, I know there's systems, there's POS systems where you can, log into your serving or your non-service work, but that's not the way restaurants work. And it's just unfair to the servers to have to do work and get paid $6.38 an hour instead of getting paid minimum wage for a prep cook. You're a prep cook. You're a hostess. You're a cashier. You're a cleaning person. I mean, cleaning people make $30 an hour. I've had to clean refrigerators. I've had to clean the restaurant. That's how it goes. That's what it is. If you don't want to be a service worker, then, I'm not saying it's all restaurants, but that's my experience. Thank you.
Next, I'd like to call Ann Hughes, Representative Ann Hughes, who was a server.
Thank you. We'll be serving firsthand testimony about what it's like to be in the lowest economic rung and to just do this work because we need to feed our families. I'm State Representative Ann Hughes. I was a server. I'll be welcoming you today to this menu. I was a server right out of college, and my student loan payment was larger than my rent per month. So after I did my day job in human services, I took a job as a waitress, and I was appalled that we got paid about $3.60, and a lot of patrons never tipped at all or would tip only maybe 5% or 10%, and that we had to pay for broken glasses, broken bottles, caused by collisions when you're going in and out of a swinging door with your service tray. And I said this, and pervasive harassment from patrons, from colleagues, from employer. And we didn't even talk about that. What we talked about was how can we band together and demand fair wages. And the other waitresses said, I can't afford to do that. If I did that, I would lose my job and somebody else would come in and just put up with it. And these are non-unionized, non-organized waiters that cannot afford to lose the little amount that they make because they are trying to feed their families. And I, as a co-chair of the Progressive Caucus, stand with the workers that were excluded from our increase of minimum wage. On the menu in New York City is minimum wage for everybody, and the restaurant industry is so thriving that they're considering serving that in all of New York. And I think we need to increase minimum wage for everyone and switch to that business model where everyone's thriving. And you go out to eat and you know that you are paying a fair wage for everybody that is helping to serve your food so that those people can serve their families. And that is what I'm going to be serving on the menu in my testimony today.
Thank you very much. And now I'd like to call Labor Committee Co-Chair Robin Porter.
Good morning, and thank you all for coming. As you've heard, we have some dire consequences, I think, that would erupt if we go through with the legislation as written. I think the biggest problem that I have with the current iteration of this quote-unquote compromise is that we have not been able to find anything in this legislation that benefits workers. And I stand here today as the chair of the Labor and Public Employees Committee. My first priority is making sure that the workers in the state are taken care of and that their rights are upheld. And I really feel like we need to slow this train down and get everyone to the table and make sure that when we say we have a compromise, if that's what we're going to have, that's what we have in truth and in spirit and in letter of the law. I feel that it's unjust. It's been very unjust that the people that are being impacted the most, that have the most intimacy with this legislation, have not been at the table. I say it all the time. The people closest to the problems are closest to the solutions. If we're trying to truly solve this issue, we cannot, I repeat, we cannot do it without the voices and the experience of the people that are actually doing the work. It is not fair. It's been decades that this has been on the books. Restaurants in this state are thriving. Why is it that the people that are providing the pathway to their prosperity are not thriving? Why is it that the equity is not there, not seen? And what we're talking about doing, in my opinion, and I must say in the legal opinion of many that I've talked to, is that this is not the thing that we need to be doing. So I look forward to this public hearing. I look forward to hearing from the restaurant owners. I look forward to hearing from the workers that will have the courage to come forth, because a lot of them, unfortunately, are starting to bow out due to the fact that they are in fear of retaliation and in fear of losing their jobs, which I think within itself is a crime. No one should be in fear of coming forward and speaking in this building and telling the truth about what it is they are experiencing and what it is they're going through. We're talking about over 60% of these people are women, and specifically women that look like me, okay? Single parent moms, divorced moms, struggling, working 2 and 3 jobs to make ends meet. And here we are talking about giving a break to the people that don't need a break. And until we start to build this house from the foundation up, we are going to never get this right. In this state or no other state, when you lift from the bottom, everybody is elevated. And we have got to pay better attention to the people who need us the most, because when we take care of them, we'll be taking care of ourselves. We can't talk about strong communities until we talk about strong families. And these are the families that need us now. And they need us, and this is urgent. There's a sense of urgency that I want people to feel, and I want to encourage the workers that are terrified to come forward and to testify. If you can find the strength to do so, do so. But if there's a legitimate cause that you cannot and will be fired, don't show up. Because you have people like me, Representative Hughes, Representative Winkler, and a host of others. You know, Senator Winfield is en route. Julie Kushner is en route. You know, my other co-chair. We stand with you in this fight, and we will continue to fight the good fight until we get this right. And I'm sorry, how could I forget Michelle, Representative? But there are many others that aren't here as well. But we stand together because we know united we stand and divided we fall, and we will get this right if I have anything to do with it. Yeah. Thank you all for being here, and thank you to Sal and to Jennifer and to all the people that made this press conference possible. Thank you very much.
I'd like to take a couple questions, but first I just want to say how brave it is for our servers to come up and speak. They have almost no protection from retaliation. So they're truly brave. And I think that'll also suppress some of the testimony from the servers today as well. Do you have any questions?
Can you just outline exactly what it is that you oppose in this draft legislation?
So,
I mean, it does still allow a server to bring a tip, correct or no?
it does, but in some cases, if there is wage theft, it doesn't allow for attorney's fees. For those, there are some restaurateurs that are saying, look, we followed the 80-20 rule. What's the problem? So that's one of the reasons. One of the first things you look at is this disclaimer that's on the DOL website. It's on page 1. It says, please do not use the 80-20 as any kind of a guidance. Don't use this following language as any kind of a guidance. It's right there. You can't get to the first word of the guidance on the website until you read the disclaimer. So for them to say, so the legislation would be, well, I relied on this 80-20 rule, therefore, even if I do owe the workers money, I don't have to pay for the attorney's fees. So in that situation, how can a server spend a few $1,000s for an attorney and then not get the attorney's fees trying to recover $100 or $200? Yeah, sure.
Representative Mike Winkler. You heard people say this law has been on the books since 1950, but the law was only been protested by the restaurant owners lately, and that's because of the advent of the class action suit. If a waiter or waitress lost $400, they could sue, but they would lose more than that in attorney's fees, and no attorney would take the case because the contingency wasn't enough. So now that it's been figured out how to get whole groups of workers to be able to file, the money is there, the lawyers are there, and the restaurant owners don't want to pay. It's accurate that this theft has been going on forever, but the ability to redress it just occurred, and that's why we're here today.
Sal, I'm sorry, I apologize.
James, do you want to add anything?
Just to reiterate the point that I'm a legal aid lawyer. I'm one of the only attorneys in the state who would bring these claims as individual claims, and there's only 2 or 3 of me in all of Connecticut, because no private attorney could afford to bring, again, a case worth $500 or $600 on a contingency.
Sal, I apologize for being late, but is it your position to follow you today that the wait server employees should receive full minimum wage plus tips as opposed to the tip wage which was locked in when they
That's not our position today. That's how many states have resolved the issue. They get minimum wage plus people still tip. And so it has resolved that issue for many states. All we're saying here is the process hasn't been broken for 70 years. What the restaurateurs are afraid of is that now a judge said you can file class action lawsuits. And that's what they're afraid of. And so this yeah. Oh, sorry. Julie Kushner, other co-chair of the Labor Committee.
I had an in-district event this morning. I apologize for being late. But to answer your question, too, I think, there are 2 separate issues. They're related, obviously, but the issue of wage theft is separate and apart from what wage you earn. And so this case and what's going on around this is really about wage theft and how do you, there are other employers who pay minimum wage but still steal wages from workers, and they have the opportunity to pursue claims for those lost wages. And so that's really the core of what this issue is about.
And the second piece that the proposed compromise legislation does is it takes just this class of workers and says, for you cannot you cannot have legal redress through a class action system.
So how many tip workers are there in the state, and do you know when the last time that tip wage was increased? And I had another question too, like how does this work for, like, say, bus staff who are, sometimes they share tips?
There are situations, I'm trying to see which question to answer first. So there's we believe 48,000, give or take a couple hundred, 48,000 tip workers. I'm not sure the last time they got a raise.
It would have been when the last time the minimum wage was increased, because previously it was linked.
That's what I mentioned earlier when I said this year they made a conscious decision to de-link the tipped wage. So anytime the minimum wage went up, so did the tipped workers. This year there was that's part of the double whammy with this, right? They don't get they don't get a share of the 90-cent tip that everybody else got 10 days ago.
So the previous ones were linked.
They were linked, yes.
What happens when they pool the tips? Are those people still considered tipped workers? Is it less?
Maybe?
Yes.
Yeah.
They're tipped workers, but they're not,
Again.
it depends on the situation. Tip pooling is a very complicated, what's legal and not legal can be a bit complicated, but by and large, what this legislation takes away from is people who are doing service work at tables. So that could include anyone doing service work at tables, anyone who's earning the sub-minimum wage.
So what are the chances for this legislation moving forward? I mean, no special session has been scheduled yet, but.
Well, as I said, this is the first time we've ever testified on a working draft of a bill. That's kind of how weird it's become, right? Both the fact that the legislation, the initial legislation that would have taken away property rights from workers happened in an implementer that with no public hearing or anything. So we don't know. It's hard to ask a legislator if they're for or against something that they haven't seen before, and there's no finished product. That's the process is also part of what we're complaining about.
Do you believe that negotiations over this legislation were used by some lawmakers to get something in the bond package?
I'm not going to speculate. I'm not going to speculate.
Do the lawmakers want to add anything or no?
I guess they don't want to speculate either.
I didn't have my camera ready for that much.
Well, if people are doing that, then we'd like to hear it. If you know that colleagues are trying to leverage something, then tell us. If you don't, then say you don't.
I can only speak for Representative Porter, and that is not the case for me.
Sal, what percentage of the wait serving and bartending population is ordinary?
A very small percentage. Usually, HERE, the hotel employee, restaurant employees, they have like a few hotels and things like that, but most restaurants are not.
And UFCW has Foxwoods.
And UFCW has Foxwoods, but most restaurants are not unionized.
So it's less than 10%.
Yes, yes, safe to say.
And I just want to add this. I think if we were really talking about a compromise, the more I think about this, because of the issue of wage theft and the things that happen in the restaurant business, if we're going to have a sub-minimum wage and we're going to only apply that to tip workers, then I say if you're a tip worker, that's all you do. You don't do minimum wage work. I mean, it's a no-brainer. Why aren't we talking about that? That would be the compromise that would be more palatable for me. If I'm being hired at sub-minimum wage, then I must only do the work that applies to that wage. Then we take out all the confusion. You don't have to keep up with anything. This is what you've hired me to do. This is what I'm going to do.
Can I say? Yeah, and I'm sorry I wasn't here to hear everything that was spoken about, but there's been a representation by a number of people advocating for this legislation that we're really talking about a few seconds here, cutting up lemons, or a few minutes over here, rolling silverware and napkins. That happens clearly, but that's not really the issue. The real issue is people are being brought in an hour before their shift starts to do prep work, or 2 hours before and an hour after shift. And so the real question is, when they're not waiting tables or doing service work, should they be receiving the sub-minimum wage at that time? And I think that is the tradition in restaurant work. So we're talking about something that's gone on for years. The real issue is it wage theft if you're not, number one, tracking the hours and the time that is being spent, and number two, whether in fact you should be paying sub-minimum wage.
One of the issues is these buffet restaurants, right, or salad bars, where they have to set them all up and then wait on tables besides.
And I think the same issue applies. If you're doing it for a few minutes a day, like has been represented, you know, that's really not the core issue here. It's really when you're doing it for hours and you're not earning a minimum wage.
Yeah, like if you're refilling the olives or something, that wouldn't be an issue, but
No.
if you're setting up the whole thing.
And just to be clear about the just to be clear about the regulation as it exists now and has for 70 years, if you're doing work related to your service, it's part of your service work and can be paid at a sub-minimum wage. So if you're cleaning the table, the famous example of filling salt and pepper shakers and all that stuff, that's already rolled into the rule. What we're talking about is work that is clearly not related to your service, like cleaning the bathroom, cleaning grease traps, mopping, sweeping. That's not work for which you can earn a tip. If you can't earn a tip, you shouldn't be paid a sub-minimum wage. If you are, the rule has been the same for 70 years. If you can make a tip, you can be paid a sub-minimum wage. If you cannot earn a tip, you cannot.
Yeah, that's been one of the myths that people have tried to perpetuate, that if you're filling salt shakers or you're rolling napkins, that, you know, to have to keep track of that. That's just not true.
Ask the workers.
Yeah. Well, you should not be getting a tipped wage if you're asked to clean the bathrooms. Simple as that.
Okay, thank you, everyone.
Thank you.